Domestic violence battery charges are very common in South Florida. Tanner Demery of Demery Law PLLC understands the seriousness of these charges and has prepared this video to educate viewers on the seriousness of domestic violence and the penalties associated with the charges. In Florida, domestic violence battery is a very serious offense with statutory penalties. This video will cover the definition and elements of domestic violence battery, as well as the statutory penalties and additional conditions that may be imposed upon conviction. In Florida, the definition of domestic violence encompasses a wide range of violent acts, including battery, committed by one family or household member against another. The elements of battery for domestic violence require intentional and non-consensual physical contact that results in harm. Florida law defines domestic violence as any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of one family or household member by another family or household member. The elements of battery for domestic violence include the actual and intentional touching or striking of another person against their will, or intentionally causing bodily harm to another person. The penalties for domestic violence battery in Florida vary. A first-time offender can be convicted of a first-degree misdemeanor for committing battery. If adjudicated guilty of a crime of domestic violence and the person has intentionally caused bodily harm, it is mandatory that the court order a minimum of 10 days in county jail for a first offense, 15 days for a second offense, and 20 days for a third or subsequent offense. If the crime occurs in the presence of a child under 16 years of age who is a family or household member, the minimum jail times increase to 15 days for a first offense, 20 days for a second offense, and 30 days for a third or subsequent offense. A domestic violence designation in Florida triggers mandatory minimum sentences. Domestic violence is punishable by a minimum term of 1 year's probation. A criminal defendant found guilty of a crime of domestic violence must be ordered to a minimum term of 1 year's probation and must attend a batterer's intervention program as a condition of probation. In conclusion, strict penalties are imposed for domestic violence battery, including mandatory minimum jail sentences, probation, and participation in a batterer's intervention program. The penalties increase with subsequent offenses, and if the crime occurs in the presence of a child under 16 years of age. These stringent measures reflect Florida's commitment to addressing and mitigating domestic violence. Tanner Demery, of Demery Law, PLLC, has practiced law for nearly 20 years in South Florida. As a former prosecutor and public defender, Tanner Demery has significant experience handling domestic violence matters through jury trial. Tanner understands the seriousness of domestic violence charges and knows the defenses to raise that may assist with overcoming charges of domestic violence battery. Please direct any questions you may have to Tanner Demery of Demery Law, PLLC at 954-224-0577. Stay safe out there.